Let's get into some things of the things, child. We got some stuff to talk about today, honey. We got some stuff to talk about. Hit that like button. If you are new here, go ahead and hit that subscribe button. We have a great time over here. You meant what you said when you said it. Really be expect, because I don't be understanding y'all sometimes. And when y'all know when I say y'all, you know I'm talking about y'all. You know I'm talking about y'all. Makes me that all these people that got something to say have been actively involved in the political process in their world. I don't believe it. You ain't gonna convince me. I know y'all love me. What's up, you guys? Happy Tuesday, or as I like to call it, the day before my birthday. Come on in, you guys. We're going to talk a little bit today. We are still on verdict watch. Excuse me. We are still on verdict watch. So at any point in time, it can be breaking news. And if and when the verdict comes in, y'all know that's what we're going to shift to if anything comes in. I do know that the jury did ask the judge for the testimony from Cassie's testimony from the Intercontinental incident. And I believe, the security guard who took the bribe, they asked for that transcript again. So not sure, I'm not about to speculate what that means, but that did happen. So come on in, you guys. Let's talk about Jay-Z. And this is connected to Diddy because, as you guys know, one of the lawsuits that Tony Buzbee filed, he initially did not identify Jay-Z as part of the situation. But then he went back in and he added Jay-Z. And as we guys know, Jay-Z, he fought vigorously. He vigorously fought as it related to saying that it was false allegations. The lawsuit, girl, they just been asking for parts of transcripts. Right. They've been asking for, right. Well, Cassie testified for a week. So I'm sure it was just, like I said, the part from the Intercontinental, right? Or was it more specific than that? They asked for more stuff. Yeah, so they working. Okay, the jury is working. I do not think we're gonna get a verdict today because it sounds like they still reading over stuff, debating stuff. And let me say this to you guys. Whether we like Diddy or not, whether we think Diddy is guilty or not, I think all of us, if we ever find ourselves in a situation like this where we are fighting literally for our freedom, I think we want the jury to be diligent and double check and triple check. You know what I'm saying? So let them take their time. Let them cook. And like I said, when we get something, we'll come back to it. Now, we have two things that we're going to get to today. We're going to get into this Jay-Z situation. And then we're going to talk about Remy Ma. We're going to get into that. So let's go to it. The YouTubers are there doing photo shoots outside the car. I know, right? Baby, they having a good time. I told you guys, if the trial was still going on, I was going to try to go up there this week. I knew I couldn't go last week because I was going to be on vacation, and I knew I couldn't go the week before because I was still at work. But if the trial has still been going on this week, I was going to drive up just for a day or two. But Mims don't know it, but I was going to crash out on his couch. I was going to crash on his couch. He ain't know it. But anyway, let's get into this. So today what we found out is that Jay-Z actually ended up suing Tony Buzbee and I believe the Jane Doe for defamation. And so Tony Buzbee filed for a motion to dismiss. He said, listen, he said, listen, this is bogus. It doesn't meet the standard, and we want this case withdrawn, thrown out, whatever the legal term is. And what we found out today is that the judge granted that request. So now listen, the court's decision is 65 pages long. We are not, as much as Cajun may want us to, we are not reading through 65 pages, but we are going to read through the beginning. We're going to read through a little bit of the middle, and then I'm going to read you guys the judge's decision, the conclusion. But we will not read 65 pages, okay? So come on in, get comfortable, kick your feet up, and as always, thank Tracy, because baby Tracy was on it, okay? Y'all thank Tracy, all right? I wondered what that temperature outside the court will be after the verdict. All right, let me share my screen. Let's pull it up. Cajun, you're going to be waiting. That's never going to happen. Cajun say he's still waiting on that 4,000-page lawsuit. He's going to be waiting because it's never going to happen. All right. Cajun, make yourself useful. I want you to remember 48. Remember page 48, okay? Make yourself useful, Cajun, because we're going to start at the beginning and then we're going to go to page 48, okay? All right, let me make this a little bit bigger so you guys can see it. And then we're going to get into it. That would have been an amazing birthday gift. For who? For who? All right, so as you can see, this was filed on June the 30th, so this was yesterday. Superior Court of the Superior Court of the State of California for the County of Los Angeles, West District. Sean Carter. Oh, wait a minute, Tracy, did you have to pay for this? California, you usually have to pay for it. Tracy, you better, see, I'm gonna smack Tracy, y'all. Y'all just don't know I'm gonna smack Tracy. Tracy, you ain't have to pay for this, girl. Moving right along. As you can see, Sean Carter versus the Buzbee Law Firm. Order regarding defendants, which would be the Buzbee Law Firm, defendant and Anthony Buzbee special motion to strike. Okay. So they actually had a hearing back on April the 8th of 2025. And the judge heard both sides arguing why this case should not be thrown out. And then the judge made his final ruling on yesterday. So, again, we're going to read a little bit of this background, and then we're going to read a little bit of the middle when it talks about defamation, and then I'm going to read you guys the judge's final decision. All right. As you come in, hit the like button, please, and thank you. If you're new here, go ahead and subscribe to the channel, kick your feet up, and let's go. Plaintiff John Doe, later identified as Sean Carter, filed this defamation extortion action against defendants, the Buzbee Law Firm and Anthony G. Buzbee. Currently, before the court, our defendant's special motion to strike, which is also known as an SMS. And of course, Sean Carter opposes. The SMS has a long history. The original hearing was set for February the 25th, and the court, after hearing oral argument, adjourned by the hearing to give the parties an opportunity to address new evidence Carter claimed to have. The court had hoped the parties would agree on a briefing schedule, but alas, such was not the case. Even so, the additional papers have been filed. One question, hold on, let me make sure I didn't scroll too far. Okay. One question addressed below is whether the court ought to consider any of the new evidence Carter has submitted. Carter requested that the court consider it via an ex parte application. Defendants contend that the new evidence is improper procedurally and that even where it considered, the motion ought be granted. Carter takes a different view. Obviously, he does. The new evidence was the focal point of the hearing on April the 8th. Having researched the arguments raised, much of the discussion, the court now issues this ruling. Much of the discussion below is taken from the court's earlier tentative because it still applies. However, the court deals with the motion as originally brought and also the new submissions. So they do talk later on in this brief about what this new evidence is that Sean Carter and his attorneys submitted. So we'll get into that. We'll get into a little bit of that. As noted in the prior tentative, there is a fairly high amount of rhetoric here. The court understands why that would be. The allegations on both sides are salacious, and the court wonders whether the court wonders whether the court is the real audience for some of the language used. Ooh. So the judge is like, were y'all really talking to me, or were y'all just trying to get some sound bites? Okay. That's my interpretation. Okay. The court reminds counsel that the court's duty is to decide the case according to the law. Content and not adjectives will carry the day. So, like, y'all can be salacious. Y'all can bring up all that extra stuff. Y'all can bring up baby oil and all them other things to try to, you can distract the people, but you can't distract the court. The court is only looking at the evidence. Y'all can keep all of that, okay? This admonishment rings especially true in light of the new evidence and repeated filings by both parties. Baby, it sounds like this judge is sick of both of them. This judge is sick of both of them, it sounds like. Okay? Judge said, I need both y'all to get up out my damn courtroom. Okay? So, they get into the original evidence. I feel like we know the original evidence, the demand letters, the yada, yada, yada. We've talked about this, so I don't need to go through all of this. And of course, they get into the specific statements of what was said. Again, you guys, we've gone over that. You can go back and look at old videos of what Buzbee said, what Jayz said, what Jane Doe said, what the investigator said. But let's talk a little bit about this new evidence, because I don't know how much of this we have talked about. I'm trying to give you guys the highlights because it's 65 pages. At the February 25th hearing, Carter's counsel made a surprise announcement. He stated that he had learned of new evidence. At the hearing, he could not divulge what the evidence was and that it was to give rise to the continuance. Carter has since submitted supplemental declarations that he believes bolsters his claims as to both extortion and defamation. In response, defendants submitted declarations, and finally, Carter submitted supplemental declarations. The court sets them forth now. So, baby, they was getting on this judge's nerves. They was just submitting and submitting and submitting again and resubmitting and then submitting to the submitting of the submission. They was doing a lot. The principal new evidence comes from two private investigators. Christine Henderson and James Butler both declared they do not work for Carter or Carter's counsel. And they put in here, according to Henderson, this is a quote, "I was not hired by plaintiff or plaintiff's attorneys to perform the investigation I describe in this declaration," and then Butler did the same. They state that they found Jane Doe had a conversation with her. During the investigation, both the state and Jane Doe appeared calm and relaxed. According to the investigators, Doe stated that she saw an ad from another law firm regarding the Diddy case. She said that she contacted the firm and was referred to Buzbee's firm in Texas. She stated she was flown to Texas by Buzbee's firm in December of 2024. She denied that Carter RAPE'd her and had anything to do with the incident. Rather, she stated that Diddy RAPE'd her and that a female celebrity watched. She stated that although Carter was at the party, he had nothing to do with anything. According to the investigators, she stated that during her meeting with Buzbee, it was the lawyer that suggested that Carter was at the party. It had nothing to do with anything. According to the investigators, she stated that during the meeting with Buzbee, it was the lawyer that suggested that Carter had culpability and pushed her into that position. She was told that if she named him, she would recover a lot of money. When that investigator asked her to sign a declaration, she asked, "But how does this help me?" She stated to the investigators that she dropped the New York lawsuit because Buzbee told her that Carter had threatened to KILL her. Carter denies making such a threat. By implication, Carter contends that Doe also therefore had not authorized the demand letter that Carter asserts was extortion. Whew. Shut up, Tracy. Carter also submitted a declaration by another investigator, Pillinger. That investigator said that it was easy to find information on the internet through sites that can be accessed by the public that would call Doe's competence or credibility into question. I have a question though, and if I'm going over old stuff, Tracy, you let me know. You keep me honest. If these investigators didn't work for Jay-Z and they didn't work for Jay-Z's attorneys, why did they care? Why did they care? Why would they go find this woman in Alabama, knock on her door, and ask her questions? Why would they care? Now, maybe we covered that. So Tracy, Uncle Jay, somebody keep me honest. If we already covered it, put it in the chat. But I'm just wondering, if they did not work for Jay-Z, why did they care? Who were they working for? I'm just interested. Okay. In opposition, defendants submitted their own evidence. They denied the assertion that Doe reportedly made, although not that she made them. Buzbee also submitted multiple declarations signed by Doe using the pseudonym, confirming that Carter did assault her at the party and that the allegations in the New York lawsuit against Carter were true. She stated that she felt intimidated and afraid when she was confronted by the two investigators. Not only that they approached her, but also that they knew who she was and where she lived, given that she believed her identity was confidential. She states that she was alarmed by this. She further stated that she did authorize the demand letter before Buzbee sent it. And then here's the quote: "I authorized Mr. Buzbee and the Buzbee law firm to send a demand letter to Jay-Z and to initiate legal proceedings against him in the New York action," end quote. She stated that she dropped the lawsuit in New York because she was afraid for her life, and she realized more and more that litigating through trial would actually entail, but not because what it would actually entail, but not because the allegations were false. So she said, I withdrew because I was scared. Like, I was scared. I didn't realize how deep this was going to go. I didn't know it was going to be all the things that it was going to be. You know what I'm saying? And there it is. Okay. Lil Baby said, I thought that the lawyers hired them. That's what I thought too. But it says in this paperwork that, in the paperwork, it say that that's not what had happened. But that's a question. Can we put that in the parking lot? Y'all ever been to like a staff development or a presentation and somebody says, if you have a question, put it in the parking lot, and they give you little stickies and you can we need to put that in the parking lot. Maybe I need to make a graphic that says parking lot, because that's a question I have. Who hired these people? And we talk about not one, but two. Why was they in Alabama? They went knocking on that lady's door. How they find her? I would have been, listen, I ain't saying this woman is lying or telling the truth, because I don't know. But I would have been intimidated too if I filed paperwork and I was a Jane Doe and I thought that my identity was being protected, and not one but two people came knocking on my door. They knew my full government name and my address. Baby, I'd have told them whatever they wanted to know. I'd have told him, no, he ain't do it. No, I don't know who Buzbee is. Never talked to the man a day in my life. I'm just saying. Oh, let me put up my disclaimer. I need to do a graphic for my disclaimer too, Tracy. This is commentary, okay? If you want somebody that's just going to read through the documents and not give any commentary, I don't know where to tell you to go, but this isn't the place to be. We do commentary over here, okay? The chat has commentary. I have commentary, and we will pause when I feel it is appropriate so that we can insert said commentary. So I'm sorry if you thought this was just going to be a straight read-through. That is not what we do over here, okay? I'm so sorry for you. But enjoy the show, okay? Tracy said, we can't keep you honest. We still trying to figure that out. Girl, listen. Tracy said, we trying to figure that out. All right, let's go. There's also a declaration from an attorney discussing the negotiations leading to the dismissal of the New York case. According to that declaration, the suit was not dismissed because it was meritless, nor was the dismissal unilateral. Rather, it was dismissed because all parties, plaintiff and defendant, believed it was best for everyone to stand down. In other words, the dismissal was more in the nature of a walkaway settlement than a unilateral decision to drop the suit for nothing. Defendants also suggested that Carter's timeline that Jane Doe did not meet Buzbee until December, and that it was at that meeting that Buzbee suggested naming Carter makes no sense. The letters had already been written and the lawsuit already amended in New York. Buzbee also notes that Doe had sworn out 2 declarations against Carter that predated that meeting. According to the defense, it just makes no sense at all that Doe would submit declarations regarding Carter's involvement predating the purported meeting if Buzbee first raised Carter's involvement at that meeting. Well, that's true. That makes sense. If you said that Jane Doe told the investigators she never met Buzbee until December, yet she had already sworn out declarations that predated December that had Sean Carter's name in it, I guess that timeline does not make sense. And again, I'm not saying that she's telling the truth or lying. I'm just saying that somebody lied. Either the investigators lied or Jane Doe lied, but somebody was not being truthful. I mean, if those declarations do exist, and I mean, the court clearly believes that they exist because the court would have said they don't exist. Okay, let me keep reading. Okay. After the last hearing, the court requested that Carter produce the actual sound recording. The court ordered that all identifying information be redacted from the recording, such that the recording is just the actual sound of what had been presented in the transcripts before the court. Carter has submitted the recording properly authenticated, and the court has listened to it. Again, there is no identifying information on the recording that was filed, and the words on the audio are consistent with the transcripts. After the audio recording was authenticated, documents were lodged with the court. There was another round of evidentiary objections and submissions. This includes defendants' May 19th objections, Carter's May 20th response, Carter's June 11th response, request for judicial notice, defendant's June 11th objection, oh Lord, and defendant's June 13th supplemental response to the request for judicial notice. These new pleadings are not authorized. They said the court had considered them, but did not find the new pleadings changed the analysis. So basically, they're saying that this new evidence, if I'm understanding correctly, that this new evidence didn't really change with the court, how the court felt. Okay. We're not going to go through the legal standards because y'all know that gets into all of the legal conversation, the legalese and stuff. Let's skip down to 48. Then I say we're going to go to 48. 48 gets into the defamation. As you can see, we're about to skip 20 pages. I'm sorry if y'all want to read those 20 pages, but we're not doing that today. Sorry. We're not going to do that today. Wait a minute. I said 48. Hold on. We on page 48. Hold on. I must have had the wrong page. Oh, here it is right here. Defamation. So, and the reason why I'm skipping down to defamation, because I know that's what y'all care about. Okay. Excuse me. I know that y'all care about the actual defamation and stuff like that. Hold on, let me see what it says. Against Solange on her. Whoop. She still made those accusations before Jay-Z in a previous case. Damn, they clearly couldn't have another client. Send me an email and I will forward you the documents. Oh, Tracy said, thank you. Tracy said, if you want the full documents, she said, send her email. She put her email in the chat and she'll send you the whole thing. If you want to read all 65 pages independently, Tracy says, send her an email. If you're watching this in the playback, I'm going to put it up on the screen for a quick second. Tracy says she will send you the full document. Thank you, Tracy. So if y'all want to read the full thing on your own, there you go. Let's get into this defamation. Carter argues that his defamation claim is predicated on the 6 statements and the put that in hashtags, survives the SMS. Defamation requires the intentional publication of a false statement of fact that has a natural tendency to injure the plaintiff's reputation or that causes special damage. That is and they tell you the court case and all that. The elements of defamation claim are, I think this is important because everybody want to talk about defamation, but let's get into what a defamation claim, what the elements are of a defamation claim. 1, a publication that is false, defamatory, unprivileged, and has a natural tendency to injure or cause special damage. There is no dispute as to the element of publication here, so the court does not address it. So in other words, yes, the statements were published. We got it. Okay. An otherwise defamatory statement is actionable only if it is of the concerning the plaintiff and of the concerning or specific reference required limits the rights of action for injurious falsehood, granting it to those who are the direct object of criticism and denying it to those who merely complain of non-specific statements and they believe cause them some hurt. To satisfy the requirements, the plaintiff must show the statement expressly mentions her or refers to her by reasonable implication. The plaintiff must also show the statement was understood by at least one third person to have concerned her. And they use her because they're quoting a specific lawsuit. So it could be her, him. Okay. Oh, Lord, not Bartholomew versus YouTube. Oh, I might have to look that case up. Bartholomew versus YouTube. Publication to occur, the defamatory matter must be communicated to a third party who understands the defamatory meaning and is applicability to the plaintiff. Carter argues that he satisfies this element due to the defendant's media crusade that resulted in the audience reasonably believing that the statements were about Carter. The court agrees as to the statement which concerns statements explicitly referring to Carter as the rapist or seeking to file R charges against him. The same applies to the like, which at least strongly inferentially identify Carter as Celebrity A in Jane Doe's complaint. The other statements are less explicit and do not refer to Carter by name. Carter insists that it is immaterial given that the audience understood that the comments were about him. In particular, he returns to the like, according to Carter, that basically retroactively specified that the preceding statements A through E were of concerning him. Further, the like demonstrates that at least one member of the public was aware that the statement, or at least one of them, were in fact of and concerning him. This makes sense as to statement E, which was made on November the 18th. The statement occurred the day before the like and places in it immediate context to determine whether the allegedly defamatory statements are of concerning Dickinson. We must consider the totality of the circumstances. Okay. This requires examination of the nature and full content of the communication and the knowledge and understanding of the audience to whom the publication was directed. Both statements E and like occurred on the social media platform within a small span of time, November 18th to November 19th. Further, both concern the same subject matter, i.e. the lawsuit against defendant. The like puts statement E into context. So there were, okay, let me just say this. So there were multiple, yes, Tracy is the GOAT showrunner over here, honey. So there were multiple statements that they submitted that were defamatory. And so what the court is saying is, according to Jay-Z's lawyers, all of these statements were defamatory because they were all about the lawsuit and they were all around the same time. So even if every single statement did not specifically say Jay-Z was the person, some of the statements did identify Jay-Z. So once Jay-Z was identified as this other person as a part of the lawsuit, then that means every statement connected, i.e. every other statement that talked about this other, John Doe in the lawsuit automatically is Jay-Z and therefore is defamatory. Does that make sense? If I have a lawyer in the chat, tell me if I said that correctly, please. Thank you. So that's what the argument is. I'm not saying that court is agreeing or disagreeing, but that is what the two lawyers are arguing about. Jay-Z is saying all these statements are defamatory because once people knew that I was allegedly the other person in this lawsuit, it doesn't matter that the lawsuit was filed months ago. They now make the connection and now it's all me. Buzbee is saying, we ain't say your name. We ain't say your name. So the statements in which we didn't say your name, that's not defamatory because we ain't say your name. So that's what the conversation is. Okay. Okay. Statements A through D were made in early October. However, And however, and that leads to another temporal issue. The earliest statement was October the 2nd, and the latest statement was October the 8th. The court is not sure that like reaches that far back due to the lack of specificity in some of the interviews. The timeline works against Carter. Buzbee held the first press conference on October the 1st, had a series of interviews from October the 1st through the 8th, filed the lawsuit against Diddy on October the 20th, sent the demand letter to Carter on November the 5th, and filed the New York action against Carter on December the 8th. The furthest back that the like potentially reaches is Statement D, although there was approximately a month and a half between the like and the last interview. It implies that Buzbee may have known of Carter's potential involvement at that time. So this is a quote from an interview with Piers Morgan. And it says, right, I mean, how big an eyebrow raise are we talking about? Because you've been hearing a lot of names, presumably in the process of all of these calls coming in, and you're a pretty smart lawyer, so you can probably work out the wheat from the chaff in terms of legitimate, plausible claims here in terms of victims. I mean, are we talking about names as big as Diddy potentially? And Buzbee's response was, I expect so. I expect so. You know, obviously, those are the names the people are interested in, but I've tried to make sure people focus also on corporate entities to include banks and hotels and perhaps even pharmaceutical entities that were maybe not directly involved, but were certainly benefiting and profiting from this kind of activity. You know, those I'm interested in as well. But you know, we've seen all over social media the pictures and video of all of the various individuals that attended these parties. So I don't think that statement implies Jay-Z. I think that statement implies anybody that Diddy took pictures with. You know what I'm saying? I don't think that statement alone, I don't think implies Jay-Z. Yeah, I don't remember any banks or pharmacies being a part of this, but, you know, do tell. Okay. With that framing, at least as of October the 8th, Buzbee was strongly implying that very famous people at Diddy's level may be implicated. The court previously concluded that this implication created an inference that Buzbee already knew Carter was an accomplice. But despite its earlier decision concluding this was enough to satisfy one of the concerning tests for purposes of defamation, the court has struggled with this conclusion because it relied on heavily, if not unattainable, inferences in Carter's favor. I agree with that statement. I mean, not that the judge needs me to agree with him, but I agree. Like, I don't feel like that statement alone is defamatory towards Jay-Z. But again, they're talking about, Jay-Z's attorneys are talking about the totality of all the statements. When you put it all together, by that time, you know he's talking about Jay-Z. But, okay. After hearing oral arguments, the court believes that its concerns are valid. First, the court remains concerned about the time lapse between Statement D and the time Carter was named. Timing questions are discussed a bit below, so the court will not here give a spoiler to that discussion. In other words, the reader will have to keep going. I'm mad he put that in here. I am mad that the judge put in parentheses, the reader will just have to keep going. That is a quote. The judge got jokes. Okay. But the question dogs the court. Further, while Statement D certainly would pertain to Carter, and the court can reasonably infer that Carter would fit the description of celebrities therein, that is not enough. The of and concerning test requires more than a conclusion that the plaintiff could be the person to whom the speaker referred. It requires that a person hearing the comment would view the comment to be about the plaintiff in its prior decision. The court relied on... Okay. In its prior decision, I just said that. But this case is distinguishable. There was evidence there was a third party could have heard the statement and understood it was about the plaintiff. The court lacks such evidence here. On reflection, the court believes it's just too wide of a chasm. It was like saying that a member of a particular large group in a criminal, as opposed to all members, where the group consists of many people, a single member of the group cannot sue for defamation on the basis alone. While it might well be known that the plaintiff is a member of that group, the statement does not say that every member is a criminal, only that a particular unidentified member is a criminal. A reasonable listener might well review every member with some suspicion, but that is not enough. The right to free speech is consistent with defamation only because defamation requires the link between the false statement and the individual bringing the action. There is no evidence of which the court is aware of that a listener to Statement D would conclude that it was about Carter at the time that it was made. True, the close relationship between Carter and Diddy was hardly a Hollywood secret, but that is not enough to tether Carter for defamation purposes. The court therefore concludes that Statement D is false and of the concerning test. So they're not talking about all the statements, but they are talking about Statement D. So then it goes through some of the other statements about which ones they think is and which ones they think is not. Let me scroll a little bit further down. Hold on. So statements A through C is saying the analysis is simpler regarding statements A through C. Those statements do not identify a celebrity of Carter's stature. In fact, those statements did not focus on star power celebrities at all. Those statements talked about banks and other entities that enabled Diddy as opposed to other celebrities that allegedly engaged in the same behavior. Okay. Okay, so for these statements, the court is inclined to grant the motion as to statements A through D, but to find that statements E through F and the like make it through this element. So they're saying that out of all of the statements, 2 of the statements they do believe meet the standard for defamation. The court notes that the new evidence does not change this ruling. If the statements were not of and concerning Carter, they were not. Nothing in the new evidence will be relevant to that inquiry. All right, then it goes to defamatory per se, false assertion of fact. So it says here, Carter contends that statements E through F are false assertions of fact. It is the province of the court to determine whether a statement is actionable as a statement of fact, susceptible of a defamatory meaning versus a non-actionable statement of opinion privileged under the First Amendment. It is a question of law for the court whether a challenged statement is reasonably susceptible of an interpretation, which implies the probably false assertions of actual fact. If that question is answered in the affirmative, the jury may be called upon to determine whether such an interpretation was a fact conveyed. The court agrees that these read as assertions of fact, and there is at least a tribal issue of fact as to whether they are false. In the interviews and on the motion, Buzbee continuously emphasized the investigation he undertook to confirm whether the allegations were truthful. A court constructing an allegedly defamatory statement must consider the statement in the context in which it was made. In determining whether statements are of a defamatory nature and therefore actionable, a court is to place itself in the situation of the hearer or reader and determine the sense of meaning in the language of the complaint or libelous publication according to its natural and popular construction. That is to say, the publication is to be measured not so much by its effect when subjected to the critical analysis of a mind trained in the law, but by the natural and probable effect on the mind of an average reader. So in other words, we can't use the standard of an attorney and what an attorney knows to be defamation and the definition of defamation, but what are the everyday people interpretation? I like the word tether. I have to disagree with that conclusion. You have people who believe anyone who attended a Diddy party did something nefarious, but that doesn't make it defamation. What they're saying is just because, and that actually goes back to what I just read, just because people believe that everybody that went to a Diddy party did something nefarious, that doesn't make it defamation. That doesn't make it a defamatory statement by the law. You understand what I'm saying? Like, I understand. I get what you're saying. That's like when he was saying a criminal organization. Of course, the assumption is that everybody who was a member of the mob did something illegal, but that doesn't make it defamatory. That doesn't mean that one person who's in a picture standing next to the Godfather automatically has a defamation statement, a defamation case. That's what they're saying. I understand what you're saying, though, little baby. And again, we're talking about the legal standard. The legal standard says you can't say that just because I was in a picture standing next to R. Kelly, that now that means that everybody is going to assume, you know what I mean, that I did something nefarious by the legal standard. And that's what he literally just said. You know, he said we can't go by we can't use the mind of elite. We have to use the mind of the general public, the average person. Statements E through F are factual in nature and read in context, so is the like. The context indicates that Buzbee is proceeding with caution and only pursuing claims that have merit. An average listener would believe that Buzbee's statement truly implicated Carter as a rapist. In reply, defendant's assertion that the statements do not even name Carter. This is true for some of the statements, but as discussed previously, Carter did not need to be explicitly named, where the context makes it clear for present purposes that the comments were about him. All right, let's read a little bit about malice, and then I'm going to just read you guys the conclusion, okay? A plaintiff in a defamation action must prove the statement is false by a preponderance of the evidence. Carter presents his own declaration stating that he did not SA anyone and notes that the press has reported on material inconsistent with Jane Doe's testimony. That is sufficient to satisfy his burden in a normal case for purposes of this motion. Next, there is the question of actual malice, which is one of the hardest questions presented by this motion. Because of Carter's celebrity status and public interest in the case, he must present enough evidence to support an inference that Buzbee made the challenged statements with actual malice, as the term and used it in a case. And here's a quote: with knowledge that it was false or with reckless regard of whether it was false or not, end quote. Quote, a defamation plaintiff may rely on inferences drawn from circumstantial evidence to show actual malice. A failure to investigate anger and hostility toward the plaintiff, reliance upon sources known to be unreliable or known to be biased against the plaintiff, such factors may, in appropriate case, indicate that the publisher himself has serious doubts regarding the truth of his publication. Thus, malice may be inferred where, for example, a story is fabricated by the defendant, is the product of his imagination, or is based wholly on an unverified anonymous telephone call. Similarly, an inference of malice may be drawn when the publisher's allegations are so inherently improbable that only a reckless man would have put them in circulation, or, there are obvious reasons in doubt to the veracity, of the informant or the accuracy of his reports. Conversely, the failure to conduct a thorough and objective investigation standing alone does not prove actual malice, nor even necessarily raise a tribal issue of fact on the controversy. Similarly, mere proof of ill will on the part of the publisher may likewise be insufficient. So just saying ill will does not raise the bar. They have to prove, he would have to prove that Buzbee knew that there was a lie when he put that information out. If Buzbee actually talked to the plaintiff, interviewed the plaintiff, and had a reasonable belief that her story was true, Carter argues that NBC published an article noting inconsistencies in the accuser's story. That is true. The NBC investigation revealed supposed issues in Jane Doe's story. Most importantly, that her father could not remember driving 5 hours from their home in Rochester to pick her up in New York City. Something one might presume he would recall, assuming it was true. Further, defendants have since dismissed the New York action with prejudice. The question then is whether there is some obligation that a lawyer has to investigate a client's factual assertions before bringing suit or making a statement in public assuming that those assertions are not patently frivolous on their face in order to avoid a defamation suit. The answer is not so clear as one might think. First, while the NBC investigation supposedly revealed the above, the court is far from sure that it can accept the findings in the investigation as true for purposes of this motion. Those findings are hearsay. So from an evidentiary standpoint, the court cannot take them as facts. But even so, the argument is that it would have given Buzbee pause had he learned of it. But pause is not the same as actual malice. What y'all thinking in the chat? What y'all thinking? Tell me. Second, it could well be, and likely is the case that a lawyer who believes the client in such a situation will defeat a malice prosecution suit. But that is in part because of the nature of the attorney-client relationship and the interplay between that relationship and access to the courts. The court is unaware of authority that suggests that the same is true once the lawyer moves outside the litigation context. In other words, the law will protect a lawyer who is bringing a suit to vindicate a client's rights, even if it is later shown that the client was lying and that a reasonable investigation by the lawyer might have so revealed. But when that lawyer steps outside of that zone and starts giving press releases or press conferences, the court does not believe that the lawyer has any protection greater than anyone else. Yet that does not really answer the question either. For while the court is not sure if there are cases regarding the failure to investigate in the context of an attorney-client relationship, there are many cases discussing the general failure to investigate in the context of the actual malice standard. I'm thinking I don't have enough butter for my frosting. Oh, Lord. Okay, moving right along. To support a finding of actual malice, the failure to investigate must fairly be characterized as demonstrating the speaker purposefully avoided the truth or deliberately decided not to acquire knowledge of facts that might confirm the probable falsity of the charges. So that is, I'm going to stop there and we're just going to go to the conclusion because I think y'all get the gist of what the judge is saying. I think y'all get what the judge is putting down, okay? So let's get to the conclusion. Conclusion. The court wants to emphasize that this is a difficult motion and that the new evidence has thrown a monkey wrench into the court's reasoning, or at least its original reasoning. The court also recognizes that it is painfully obvious that the court is struggling with this motion. The fact that the court has issued a series of tentative decisions, each different and sometimes significantly so than the other one, all of them had denied the motion at least in part. After spending just about all of the time permitted under the California Constitution to consider the question, though the court has finally come to ground, this is the last iteration and is the court's final word. The SMS is a powerful tool. It is designed to protect important constitutional rights, thus ought not be denied lightly, but it closes the courthouse door, so it ought not be granted lightly either. Whereas here, the underlying case involves accusations of a truly horrible crime. The court must tread especially careful. The Constitution and constitutional rights cannot thrive where the courts become a weapon to invoke. Oh, lost my place. Sorry. I scrolled too far down. Sorry. I don't know why I lost myself. The Constitution and constitutional rights cannot thrive where the courts become a weapon to invoke silence out of fear of litigation, but neither can due process survive when the courthouse door slams shut in the face of one wrongfully accused. Our legislators sought to find a carefully crafted rule to balance those competing vital interests to allow lawsuits to be litigated whether there is a reason to believe a wrong was done, but to throw out speedily where they were being used to silence discussions or impede justice rather than further it. The court has tried to balance these competing values and has ultimately come out on the side of dismissing the action. Although the court is not wholly satisfied with this outcome, is not wholly satisfied that this is the outcome that best serves the legislative and constitutional doctrines. All of that said, and at length, this court is only the first step on the party's SMS journey. It will be for the Court of Appeals to determine whether the court got it right or wrong, or whether the suit ought to go forward or ought to end. Stay tuned. Okay, this judge got jokes. In any event, this motion is granted. In other words, the judge knows they're going to appeal it. In other words, the judge knows that they're going to appeal this decision, And once that decision is appealed, let it be what it's gonna be. He said, I already know that y'all gonna appeal this decision. Y'all don't like what I said, and let the Court of Appeals, let them figure it out. I feel like that's what he's saying. Let the Court of Appeals figure it out. Thank you, Shay D. Happy belated. It's not belated. Tomorrow's my birthday. Thank you for everything you do to keep us entertained. Sending love from the UK. Thank you. Thank you so much. No, July the 2nd is my actual birthday. I know I posted pictures on Instagram from when we celebrated when I was in Florida, because I was with my nephew who lives in Texas. So him and his kids, you know, we celebrated since we were all together. Yeah. Hold on, y'all. All right. So yeah, you guys. I mean, what say you? What do y'all think? Do y'all agree with the judge? Do y'all disagree with the judge? Do you feel like that those statements were enough to rise to the burden of defamation and malice? What do y'all think? So here's my opinion. And I'm not, you know, I'm nobody's attorney. So I didn't go to nobody's law school. So I feel like it's a very hard burden. I think people misunderstand how hard of a burden defamation is when it comes to celebrities. You know what I'm saying? Watching from Chester, Amazon. Hey, Marcus. You know what, little baby? I'm not doing this with you today. And I think we're going to definitely see Jay-Z's attorneys file an appeal, and we'll see what they say on the appeal, child. Because I'm not an attorney. You know, I ain't go to nobody's law school. But I do understand that defamation is a very high bar. Like I said, especially when you're talking about celebrities. And it sounds like Jane Doe was just all over the place. Jane Doe was the monkey wrench in this. Because if you believe the investigators, then yeah, it sounds like Buzbee was doing some shady stuff and maybe even some borderline unethical stuff. But on the flip side, if Jane Doe said, listen, I lied because I was scared because these people knocked on my door and I told them whatever they wanted to hear, then you got to throw all of that out and be like, well, there's no validity to that either. You know what I'm saying? Really B, are we having a birthday party on YouTube tomorrow? Can we do an Ask Really B about her lifestyle? I don't know about that part. Yeah, we are. We are doing a birthday party tomorrow. We are doing a birthday party tomorrow. I don't know about the Ask Really B, because I don't know, but y'all might ask me. Can we give it up to Really B again, y'all? She does everything from providing insight, making us laugh, and reading pamphlets and documents. Thank you, Lauren. Thank you, boo. Yeah, I'm actually getting ready to set that up. When I get off of here, I'm setting up the live for my birthday party. It will be tomorrow evening. Because I'm going to dinner with my parents, but we're doing an early dinner. So I'll be back home. I wasn't sure what I was going to actually be doing. So, but I'm not doing much. I'm probably go see my cousin tomorrow morning and then meet up with my parents for dinner. It's a real low-key birthday. I just came off of vacation. I'm going to Dallas next month. I'm going to Louisville in October. I'm going on a cruise in February. And I actually think I'm about to book another cruise for next summer. So it's a low-key birthday. Y'all know I did it big last summer, spent a lot of money, but had a great time. So I'm kind of keeping it low-key this summer. Y'all, we're going to be back. Give me about 30 minutes to set up the next live. We're going to be back and talk about this Remy Ma situation. I need to find the original lawsuit, the original case against her son. I need to go on my email because I know we went over it. I did a video on it, but so we're going to read what the court case is actually about. I do not need a travel channel, Lauren. I do not. I keep telling y'all, when I travel, I don't think about vlogging and all of that. I'm just in the moment. So I really don't need a travel channel because that requires me to do content and edit and stuff. No, I don't. I'm good. I'm good right here. When I travel, if I have time, I'll go live and I'll tell y'all about what's going on. But people want to see, like when you do a travel channel, people want to see the moment and experience the stuff. And I just don't want to be that person walking around video and everything and doing. It's nothing. It's no shade to those people. They make a lot of money, but I just don't. I don't have that in me. Now, if I get to the point where I can afford to travel just for business, like YouTube is paying me enough that it's a YouTube, then yeah. But usually I'm on vacation or I'm with friends and stuff. And I just like to be in the moment. Plus, a lot of my friends don't want to be on YouTube and want to do so. Then I have to worry about not getting them on camera and all of that. It's too much. It's too much. Yeah, I don't want to be. I don't. And I understand what you're saying, but I just I don't want to be caught up in that. Because I've tried, y'all. I was like, okay, I'm gonna vlog this. And like when I was going to do when I went to Paris a couple of years ago, I was like, all right, I'm gonna vlog it. Y'all, I took like 2 videos and I didn't get nothing else. I had a bunch of pictures, but I didn't have any videos of anything. I sent you a Cash App. Oh, wait a minute. Hold on. Thank you. Be safe on your flight, boo. Hold on. Thank you, babe. We're going to be back in about 20 minutes, though. Thank you. Thank you, Brown Mama. I appreciate the love. I appreciate the birthday love. Y'all, let me get up off of here. We're going to come back. Let me go find that Remy Ma situation. Let me upload the video of what happened at court yesterday with her. And we're going to talk about Remy Ma. And then I think we're going to, baby, we're working today. We're working. Then I think we're going to be live on the other channel talking about Real Housewives of Atlanta, honey, because I'm waiting to get some information. Once I get that information locked in, baby, we got a video for over there. All right, y'all, let me go. Mwah! Talk to y'all later.